Hello. Hello, good morning. Can you hear me? Good. Bonjour, buenos dias, sabah el khair, tak, and guten tag. First, I would like to apologize. My voice is not very good today, and I'm losing it. So I've drunk everything I could to try to maintain it for the presentation. So thank you for your understanding. So this morning we will go through the legal tools we have developed so far to help facilitating implementing the Stockholm Convention under national law. And I will start by recalling the mandate under the conventions to develop these tools. If you take 4 provisions contained in Article 3, 5, 6, and 7, respectively, it is stated that parties have to take measures to reduce or eliminate releases from intentional production and use. They also have to take measures to reduce or eliminate from unintentional production and use. They also have to take measures to reduce or eliminate releases from stockpiles and waste. And Article 7 sets out the obligation under which the parties are to be taken an adequate and appropriate legal framework under national law. So these provisions, under these provisions, parties will need to review their law, which may be composed of legislation or regulation. Usually it's especially regarding chemicals, as it is left to a chemical agency internally. You will see a lot of regulations which are part of the legal frameworks. What tools have we developed so far to help put into place these national legal and institutional framework, which may be composed of, as mentioned earlier, legislation or administrative and regulatory measures? We first have, and we'll go through it afterwards, a Stockholm Convention legal guidance, which aims at developing national legal frameworks to implement this convention on POPs. And then, and this is what we would like to develop more in the future, to have it in different languages as well, and to have it from more countries. We have legal case studies because we have realized that it is by exchanging information, sharing experience, that parties make the most of the national experience of other parties. So far we have Tanzania to represent the African continent, Thailand, and Canada. And last week I have discussed with Brazil, who also would like to expose their a diagnosis of the states of their national law regarding POPs, what there is and what there is to do. We'll quickly go through them afterwards as well. And another helpful tool that we have developed, and it exists for each convention, is the checklist for the legislator. It can also be a checklist for a regulator as well. It's a tool in the form of a recap table, which indeed recap the different obligations which are to be implemented under the Stockholm Convention. And there are general obligations which are highlighted in certain color, and you will have more specific obligations which are highlighted in a different color. So this tool is really for the national law and policymaker to go through these obligations very quickly, compare it to the measures that they have to implement contain, and to really, as I say, a checklist, and to really check whether they have indeed implemented each of these obligations. We have put these documents on the web, so they can be consulted anytime. And on the presentation, you have the exact address of the web page where you can find these three types of tools, which aimed at being developed and to be more specific, or to be also available in the UN official languages. So future legal tools, and please welcome to share any ideas and needs that you would have in order to develop these legal tools. We are now in the process of, like it exists for Basel, to collect the national legislation which we may receive from parties and which may be posted on the web. At least it will be another way of sharing information and experience as to the components of the national legal framework which implements the convention, and compare it with different level of developments of this framework between parties. The Conference of the Parties also provide an opportunity for parties to actually voice what they need. For example, there is a model legislation which exists under the Basel Convention. It hasn't been developed for the Stockholm Convention and for the Rotterdam Convention as well, because at the COP, for various reasons, parties didn't want that model legislation for the Stockholm Convention. So what we have so far is a checklist, which is a step before this model legislation. But if parties would change their mind and would really think this tool, legal tool, would be necessary, then they should not hesitate to mention it at the next COPs. And other future legal tools which are under development are indeed these specific case studies or these desk studies, which are a sort of diagnosis of the actual situation of the legal framework, which are to be which are supposed to implement the this international treaty under their national law. And this will depend a lot on what type of legal system they have inside, what type of constitutional legal system. Indeed, it may be very different from a common law country tradition to a more codified and civil law country tradition, where you will have more acts, more text, and more legislation to regulate very specific topic. Whereas in common law, you will also have to look at how the convention may be implemented even in court decision and case law, and not necessarily have regulatory measures or even proper active legislation. So this is something you really have to look at when implementing an international treaty like the Stockholm Convention under a national legal system, is to what tradition the country belong. And also in international law, you have also different conceptions. Sometimes a treaty will be directly applicable under the national legal system. This happens where, for example, the legal institutional system is seen as a pyramid, where at the top you have all the international treaties that are ratified by the country. And in that case, for example, it is directly, it may be directly actually relied on in a simple case in front of a judge. And this happened in some countries. We call it under international law a monist system of law, under which the legal system and the legal framework which applies in a country is just one ensemble, and at the top the international law. But what happened in many countries is the contrary, is that you have actually two groups which form a legal framework, and two separate groups, the national one and the international one. And in this type of case, there the national measures which transpose the international law will be very important. And it happens in many countries. So you will have, as a policy or lawmaker, to have to look at that. And if you're not a policy or lawmaker, but delivering technical assistance, for example, in a country, or studying the situation in another country, you will first have to look at this legal structure to understand how the legal framework will be composed of in this national situation, and what measures are possible within each system, within each example. So, toward a synergetic joint legal tool package, this is a question, and actually we indeed still have, although we have synergies between these three chemicals and waste treaties, we still have three legally autonomous legal instruments, international legal instruments, and therefore we have separated these webinars, and we will see today and focus only on Stockholm today, but the objective is indeed to have a sort of BIS joint legal kit that we will now see one by one, and therefore we welcome you very much to join the next webinars. This week it will be on Stockholm only, but in January as well as February, we will have an overall view of this legal kit, because we will look more closely at what exists to facilitate implementation of both the Rotterdam and the Basel Conventions, and you will see it's slightly different because of this principle of legal autonomy of these three treaties, and of what parties have actually decided at the COP, because indeed we as Secretariat can develop these legal tools if we have the mandate. And at first I recall the main provisions under which parties have to implement a legal framework, and as Secretariat we are here to help and assist, especially on request. Thank you. So this is the first presentation to have an overview of what you can find, and we can send you individually these tools, but you can also find them on the web. To have a better idea, we will go through, for example, the checklist, which I think is very useful for visualizing very quickly a recap of these legal obligations. It's a Word document, and it is to be read in conjunction with the legal guide, which is much more developed. It contains at least 30 pages, this guide, and this checklist is containing more or less 5 pages, and the fact that it is in the form of a table makes it more user-friendly for a legislator to go through it. And this will be, for example, very important when national measures, whether legislative or administrative, will have to be taken in a system where you have a dual conception of the international and the national sphere. So of course you may probably know that one of the first general obligation which is common to these three conventions is the protection of human health and the environment, which has to justify the measures that are taken, whether legislation or regulation or others. And we quickly went through some of these obligations at the beginning of the presentation. The first one, as contained in Article 3 and 5, are the obligations to take measures to reduce or eliminate releases from intentional production. So in this case, annexes are very important, as you probably also follow the process of listing new chemicals in annex to the convention, which actually sets out which chemicals are to be comprised in the scope of this treaty. And this is why in many cases, many national cases, these measures are taken in forms of regulations, meaning that they are taken by the administration, and usually part of the administration, specific subsidiary bodies like chemical agencies, which have the expertise, technical expertise, to take the legal, to insert a contain, which makes sense, to regulate these very technical aspects regarding persistent organic pollutants. Third obligations, and the second more specific obligation, is the obligation to take measures to reduce or eliminate releases from unintentional production. So the first one was from intentional production, the other one from unintentional productions. So where, for example, if the party has a specific exemption, well, which is very important because, well, you're probably a bit familiar with this provision. Indeed, although a chemical may be listed in annex, there is a very specific legal regime which applies with the existence of specific exemptions or acceptable purposes for which party may register. And in this case, national law implementing and giving effect, especially where it's an obligation under this legal constitutional system, there you will have the detailed measures taken to indeed actually apply, give effect to these obligations under the national system. So in this case, it's very important that technical and scientific experts work hand in hand with the policy and legal makers, because the tools are, for example, the act that the parliament may actually vote, or the regulations that a chemical agency or another part of the national administration may take. And therefore, you have to work hand in hand, both type of experts, to actually have something coherent in your implementing legal framework, to actually really cover these very specific and technical obligations which are recapped in this table. So the third specific one is actually the obligation to take measures to reduce or eliminate releases from stockpiles and waste. So again, you see in the table the color yellow, which actually is dedicated to obligations which are less specific than the three previous ones. Parties have indeed the obligation to develop and implement a plan to actually fulfill the overall and the wide range of obligations that exist under this convention. They have to transmit it to the conference of the parties within 2 years of the date on which the convention enters into force for it. And these plans are regularly updated. The convention is regularly amended, and therefore this is something within which can help in implementing a national legal framework to be adapted to a changing treaty like the Stockholm Convention, and to implement it in an appropriate way under the national legal system. There is also a more general obligation of information exchange, whereby the designated focal points have to exchange information, and this also may take the form of formal communication as well, and it may happen also in the form of the conferences of the parties as well. Another more general obligation is, of course, the obligation under which parties will have to target the public and inform it and raise their awareness and educate them on these particular subject matter, which is POPs. And for this, they indeed have to take relevant, well, policy and legal measures. This is more loose than the previous one, than the specific ones that we had seen earlier. This recap table also mentions the fact that under this convention, parties are encouraged to undertake, and where appropriate, the research and development and the monitoring of POPs, and for this they indeed have to implement the right measures so that this may be given effect to. And lastly, technical assistance obligation, which is indeed a more general one. Measures taken under a national legal framework may facilitate that, because parties will have to cooperate with other parties to provide appropriate and timely technical assistance, in particular to developing countries and parties with economies in transition. So this is where tools that we're presenting today may also help parties in fulfilling their obligations, and this can be done in different manners. So if you go through the end of this table, you will find other types of more general obligations, which in a way or another, under the national system, a party will have to undertake regarding financial support as well as reporting. So this is it for the table. I'm trying to scroll down a bit to have the end of the table. Okay. We'll manage to scroll down, but anyway, this will be sent to you, so you will be able to have a closer look. And as I mentioned earlier, you may also find this this tool on the web pages of the Stockholm Convention. If we go now quickly through the legal guide, just for you to have a view. Well, yes. So as you see, it's more, well, it's in the form of a text, and this is really to go into further detail. I'm not sure it's moving on the screen. It's moving on mine. Oh, okay. And if you can scroll down and have a look at it, and if you have any questions on it, then we can go through them already at this session. Very important, what was really encouraged as a tool to develop legal tools is actually the case studies. And we have, sorry, picked 3 different kind of countries with different level of development to have at least a wide overview of what type of concretely legal framework implementing this convention on POPs. So you can see the example of Canada and go through and you can scroll down, go through the different aspects of these case studies. Tanzania, you will also have a background on the country itself to have a better idea of the level of development, of its profile, and then you will go through each component of the national legal framework that exists there and see what they have actually taken as measures to implement the different general and specific obligations under this convention. And at last, you have Thailand, which is also a very good example. And as mentioned earlier, we're now thinking of adding Brazil. It will be developed further to a desk study that will be undertaken indeed with the national authorities there, who will help us to make this diagnosis and to see what can be and what needs to be actually further taken as measures to have an adequate and effective implementation of the convention. So this is the first webinar, but we will actually encourage more people to actually come and if they wish to share the experience through especially the second part of the session, through the questions, or also if they wish to exchange ideas as to what issues they have to face and how they have decided to tackle these issues through more lively case studies, thanks to the people who are actually in the implementation, in the national implementation of these conventions, who are actually the national policy and lawmaker. So if you have any questions, please feel free. If you would like also to share any issues you're facing and perhaps brainstorm as to a specific way of dealing with them, please, I think now has come the time to open the session for discussion and for questions, and interaction is most welcome. Thank you.